Check out carmarshal.com. The link is in the description. They help support us.
Views of libertarians, including myself and my colleagues at the Cato Institute. Now, when I say libertarians, I'm not referring to the Libertarian political party. Not that I have anything against the party, but I'm referring to libertarianism as a political philosophy devoted to free markets, private property, securing individual rights, and strictly limited government. So at Cato, which is a think tank and a 501c3, which means it's tax exempt, we don't endorse candidates, we don't endorse parties, and as you're going to hear in just a moment, we're equally critical of both Democrats and Republicans, conservatives and liberals. What we do have is a consistent, I call it minimalist view about the proper role of government. Conservatives agree with us on some issues. They tend to be the tax, regulatory, budget, all the various fiscal issues. Liberals agree with us on other issues. They tend to be issues like marriage equality, drug legalization, liberalized immigration, a tilt towards civil liberties and this trade-off between national security and civil liberties, and a non-interventionist foreign policy. So you might say, well, how is it, aren't libertarians philosophically inconsistent if they agree with liberals sometimes and agree with conservatives sometimes? That's not the way to look at it. The way to look at it is that libertarians are philosophically consistent, and it's the liberals and conservatives that are inconsistent. To illustrate that, I want to suggest a constitutional framework for understanding these differences. And that is that the structure of our federal system is best captured by looking at the last two provisions in the Bill of Rights, the Ninth Amendment and the 10th Amendment. The 10th Amendment, as I'm sure most of you realize, tells us that the national government can only exercise certain powers that are enumerated in the Constitution. Like, for example, if you look at Article 1, Section 8, you'll find a list of 18 of these, and they're power to coin money, the power to regulate interstate commerce, the power to declare war, establish post offices, and on and on. The 10th Amendment goes on to say that the powers that are not listed there, the powers that are not enumerated, not delegated, are reserved to the states, or depending on the provisions of state law, they're reserved directly to the people. So conservatives and libertarians generally agree on that pretty tightly constrained view of federal government, but there are a couple of exceptions. The first is that a lot of conservatives, but not libertarians, are willing to federalize, and by that I mean, of course, assign responsibility to the federal government as contrasted with state and local authorities. They're willing to federalize a significant amount of criminal law and civil law as well. If you want an example, in the criminal law area, just take a look at our feckless war on drugs, for which there is no constitutional authority whatsoever. The Constitution, criminal law typically is handled at the state level. And there are only a few crimes that are mentioned in the Constitution, and those are counterfeiting, treason, and piracy. So beyond that, for the federal government to be involved in drug prosecutions is just contrary to the constitutional text and structure. If you want an example in the civil law area, take a look at the conservatives' pitch for medical malpractice reform. Now, I have to agree that medical malpractice rules really do need to be reformed. But ask yourself this threshold question: where in the Constitution is it authorized for the federal government to get involved in medical malpractice reform? And the conservatives' answer is that this is a regulation of interstate commerce, and therefore comes under the Commerce Clause, where the Congress does have power to regulate interstate commerce. Well, if you know anything about malpractice, typically it's a patient that lives in a state that's suing a doctor that lives in the same state about an injury that occurred in the state where both of them live. So how this gets morphed into a regulation of interstate commerce is anybody's guess. Libertarians, of course, invoke a quite different principle, and that is no matter how worthwhile the goal, no matter how certain Congress is that it's identified a big problem, no matter how positive the members of Congress are that they know how to fix the problem, the libertarian principle is no matter how worthwhile that goal, if there's no constitutional authority to pursue it, then the federal government has to step aside and leave the matter up to the states or the private parties, even better. Of course, that was the original design. That is not what has transpired. Today, the federal government immerses itself in matters ranging from our public schools to hurricane relief to welfare, retirement systems, medical care, family planning, housing, even aid to the arts. You know, take a look through the Constitution, see if you can find anything that would justify the federal government getting involved in aids to the arts. So that's one area where conservatives and libertarians differ from one another. A second is that conservatives are far less anxious than libertarians about concentrating a lot of power, particularly national security power, in the executive branch of government. Libertarians remind their conservative friends that too much unchecked authority in the hands of the executive branch threatens this notion of separation of powers, which has been a cornerstone of the Constitution since it was ratified 2.25 centuries ago. So the executive branch, the administration, and I don't just mean Trump or Obama, you know, Bush as well, back on and on. The executive branch may not by itself set the rules, because that's not an executive function, it's a legislative function. And while the executive branch may prosecute infractions, it may not determine guilt or innocence, which is not an executive function, it's a judicial function. And of course, it may not determine whether or not it, the executive branch, has itself behaved in a manner that comports with the Constitution, because that too is a judicial function. So that's the powers of government perspective, grounded on the 10th Amendment and the separation of powers doctrine. Now, I mentioned the last two provisions in the Bill of Rights. Of course, the other one is the 9th Amendment. The 9th Amendment doesn't talk about powers. It talks about rights. And what the 9th Amendment says specifically is that the enumeration in the Constitution of certain rights doesn't mean that those are all the rights that we have. We have all kinds of rights that are not listed in the Constitution. So that these rights, by the way, were rights that we had before the Constitution was ever written, or before the federal government was even formed. And this provision, this 9th Amendment that says that there are more rights than there are that are specifically listed, that imposes another powerful discipline on federal behavior. Of course, what it means is that if the federal government exercises only those legitimate powers that it has in accordance with the 10th Amendment, only the powers that are specifically listed, the 9th Amendment goes a step further. It says that even that small list of powers can only be exercised in a manner that does not violate our rights. And if you want to know what rights can't be violated, it's not just the ones that you see in the Bill of Rights, like speech, religion, protection against unreasonable searches, the right to bear arms, etc. It's all of those, to be sure. But it's also this virtually infinite list of rights that we had pre-government, pre-Constitution, and that we still retain. As a matter of fact, if you look at the 9th Amendment, it talks about the rights retained by the people. You can't retain something unless you already had it. So we had those rights before the 9th Amendment was even ratified. And by the way, if you note that presumptions of the 9th and 10th Amendment are exactly opposite one another, and if you get that, I think you get the structure of the entire federal system and of the Constitution. The 10th Amendment says if the power isn't there, the government doesn't have it. And the 9th Amendment is just the reverse. Merely because the right isn't there doesn't mean that individuals don't have the right. Individuals have all kinds of rights that existed before the Constitution was written. So if you wanted to identify a single constitutional provision that distinguishes libertarians from conservatives, I think it would probably be the 9th Amendment. The conservatives treat the 9th Amendment as an inkblot, to use a term that was first coined by former judge, the late former Judge Robert Moore. He said the 9th Amendment should be ignored because nobody knows what it means. It's as if somebody spilled ink on the part of the 9th Amendment that would have identified all of these unenumerated rights that the libertarians say we have. And well, conservatives don't treat the 9th Amendment as an inkblot, but not libertarians. Libertarians treat the 9th Amendment as if it means something. They argue that it means our natural rights, the rights that we had before the government was formed, before the Constitution was written. Now, what kinds of rights are these? These are all the so-called negative rights. It sounds like a pejorative term, but it's not meant to be a pejorative term. Negative rights are just rights that require only negative obligations on the part of other people, not affirmative obligations. So leave us alone. It's a negative obligation. And negative right means all you have to do is leave me alone, don't exercise force or fraud against me. Those are negative obligations. Quite different from positive rights, which require you to act affirmatively to benefit me. The Ninth Amendment has to do with negative rights and not positive rights. Now let's see if we can flesh that out just a little bit. Let's talk about the right to the pursuit of happiness. That's a negative right. I can pursue happiness. I don't need your help. Just stay out of my way. Don't exercise force or fraud against me, but you only have a negative obligation to leave me alone. Suppose, however, I had a right to happiness. Not the pursuit of happiness, but the actual attainment, the realization, the achievement of happiness. That would be a positive right, because if I exercise that right to happiness, and by the way, when I say I have a right, it presupposes that I have a remedy if the right is violated. If you have a right and you don't have a remedy, it's as if you didn't have the right at all. So if I have a right, an enforceable right to happiness, you can see that it would impose obligations on each and every one of you. At a minimum, it means you can't do anything that would make you unhappy. Because if you acted in a manner that made you unhappy, and I have an enforceable right to happiness, I can go to court and get an injunction that tells you that you have to stop making me unhappy. Of course, if you did have to stop, that might impede your own right to the pursuit of happiness. So you can see that positive rights, if you have a positive right, I have a positive right, they can't coexist. So the Ninth Amendment refers to negative rights and not positive rights. Now, you know, I talk about this abstraction, like the right to happiness as a positive right. And the positive rights that we deal with every day are not these abstractions, but they are real, live issues, like the right to welfare, the right to a minimum wage, the right to housing, education. If I have a right, an enforceable right to housing, it means that somewhere, somebody, maybe one of you, has the obligation to provide me with a house. If I can enforce the fact that I need a house and I don't have one, then of course this is usually done through the tax system. Right? So you are compelled to provide me with a house. You don't do so by going out literally and transferring your home to me, but you do so by contributing tax dollars, and those tax dollars are used to give me a house, or education, or welfare, or minimum wage, etc. So liberals, of course, embrace these positive values. And that's why liberals embrace big government. What's the link there? Well, positive values require coercion, because occasionally the person who's told that he has to provide the right for somebody else doesn't like that idea. You know, if you tell me I got to provide you with a house, I may prefer to have a house for myself or for my family. I may prefer to keep my tax dollars. So what happens when I disagree and I don't want to abide by the government's dictate that I provide you with a house? Well, I'm compelled to do so. And the only entity in our system of government that's authorized to use force is the government itself. So that's why liberals embrace big government, because they embrace positive rights. Positive rights and big government go hand in hand. Positive rights require compulsion for people that don't want to provide the positive rights. And compulsion means some entity that's authorized to use force, and that is the government. So we're now hearing, paradoxically, particularly in this post-9/11 environment, from liberals, that, well, big government may be good for a lot of things, but it can't be trusted on some things like civil liberties. So it is strange that the liberals distrust, I think healthy distrust, big government when it comes to civil liberties. Doesn't extend to distrust of big government. All these other areas like government's support of Social Security, for example, or for that matter, refusal to support school choice, or the elimination of regulations that cover everything from the size of the naval arms to the ergonomics of office equipment. So why is it that the liberals can't see past two particular agencies of government when they're worried about big government? All the other agencies can get bigger and bigger and bigger, and the liberals find that to be eminently satisfactory, but not the Defense Department. and not the Justice Department. And oddly enough, those two agencies are indisputably charged with a legitimate function of government, which is to protect us from domestic and foreign predators. So, imagine if Congress were to delegate to the Justice Department the power to enact regulations over the trade-off between national security and civil liberties. And Congress said to the Justice Department, here's your guideline. Keep us safe from the terrorists. Now, folks on the left would go nuts, and they would have every right to do so, because it is not the job of the Justice Department to craft legislation that would govern this trade-off between civil liberties and national security. But when the same Congress delegates to the Environmental Protection Agency the power to provide, to craft regulations regarding the trade-off between economic growth and, say, clean air, and doesn't give the EPA any more guidance and keep us safe from pollutants, the folks on the left applaud enthusiastically. So is it possible that pollutants are a greater threat than terrorists? It's not possible. But what is possible is that the left has a selective indignation about big government. And that reflects an inconsistency in the liberal mindset, just as there is an inconsistency in the conservative mindset about the proper role of government. Of course, that's the foundational question. What is the proper role of government? And I'm suggesting to you that the Constitution, in assessing that, the Constitution can be viewed through these two prisms. The powers of government prism, which is the 10th Amendment, the rights of individuals prism, which is the 9th Amendment. And if you want libertarianism in a nutshell, it is that libertarians view the powers of government very narrowly and the rights of individuals very broadly, and we would argue that that was precisely the vision of the framers. So, now I've offended most of you. So let me turn to the topic, which is the role of the Supreme Court, and whether or not the Supreme Court has actually abided by or has it subverted the Constitution. So it's been 227 years since the Constitution and Bill of Rights were ratified. During that time, post-Bill of Rights, which are the first 10 amendments, as you know, the Constitution's only been amended 17 more times, which is quite extraordinary. Why have there been so few changes? 17 times, and most other countries have had 17 constitutions during the 220-some years. So we've had 17 amendments. So why have there been so few changes? I mean, the framers could never have imagined what this 21st century would look like. Well, I think there are at least three reasons, core reasons, why there have been so few amendments. And two of those reasons are pretty good reasons. One, not so good. The first good reason that there have been only 17 amendments is that the Constitution was written by these geniuses, and they had a vision of liberty that's every bit as relevant today as it was back in 1789. The second good reason is that they had the foresight to craft Article 5, which provides the amendment process, and it makes it very difficult to amend the Constitution. Some would even argue maybe a little too difficult. But in any event, it is difficult. 2/3 of both houses have to propose amendments, and they have to be ratified by 3/4 of the states. And that's a pretty tough hurdle, and that's why we've had so few. That's one of the reasons we've had so few amendments, a stable constitutional framework. So the one bad reason, I think, that we've had so few amendments is that the Supreme Court has accomplished through the back door what the amendment process could not have accomplished as it was prescribed in the Constitution through the front door. The modern court, I think, seems to have, on a number of occasions, lost its compass, and that has profound implications for all of us. So I want to tell you about a few cases, and I've picked a few. They're old cases, but they have relevance today, and that's why I'm going to talk about the ones that I'm going to talk about. And that's because you pick up the newspaper, and these cases are really important, even though you won't see them cited in the newspaper. The first case is a case from 1937 called Helbring v. Davis. It's about the constitutionality of the Social Security system. So, we don't see that litigated now, but we do see the constitutionality of Obamacare, the constitutionality of welfare, and a whole lot of things. So, in assessing this, you have to think like a judge. So it's not whether Social Security is a good idea or actuarially sound or whether it's nice for guys like me to get their check in. The issue is, where in the Constitution is the federal government authorized to create a system that, first of all, requires us to provide for our retirement, how much and how we are to do so. And the proponents of the Social Security system, when this litigation came up, pointed to the General Welfare Clause, the power to tax in order to provide for the general welfare. Now, this was originally a battle between Madison and Hamilton. Hamilton's view was that the power to tax to provide for the general welfare is an extra added power over and above all the other powers that are listed, as I mentioned, in Article 1, Section 8. So Hamilton said, look, here are these powers in Article 1, Section 8, and in addition, there is this power to tax in order to provide for the general welfare. Madison said that can't be the case, because everything can be characterized as providing for the general welfare. It's open-ended. And so what we would end up with, if we did it Hamilton's way, we'd end up with a constitution that authorized a government of virtually unlimited power. And we know that the purpose was to restrain the power of government. And Madison went a step further. He said, not only isn't the General Welfare Clause an extra added power of Congress, it's actually a restriction on Congress. Because what it really means, according to Madison, is that even if Congress exercises its legitimate powers under Article 1, Section 8, the powers that are listed in the Constitution, there's another hoop that Congress has to jump through. It can't exercise even that limited list of powers in a manner that does not provide for the general welfare. A manner that provides for what Madison called factions and what we today call the special interests. So Hamilton thought it was an expansive, it's very expensive also, actually. It was an expansive clause that gave government more and more power. And Madison thought it's a restriction on the exercise of power. Well, long story short, the courts took a look at this at Helper v. Davis, and then Hamilton won, and Madison lost. And that opened up the floodgates, through which the redistributive state was ready to pour, taking money from some people and giving it to other people, and using this general welfare clause as justification. And if you want the most recent and biggest example of that, just take a look at Obamacare. Now, the Obamacare legislation said, as you well know now, that you were forced to buy insurance, health insurance. And if you didn't buy health insurance, you would be penalized for not buying health insurance. And the courts had to look at this and see if it was constitutionally authorized. The administration said it was authorized as a regulation of administrative commerce, but the courts came up with a different rationale. They said it was authorized as an exercise of the power to tax in order to provide for the general welfare. Of course, the folks that were against Obamacare said, where do you see the power to tax? It's a penalty if you don't buy health insurance. It's not a tax. But Chief Justice Roberts invoked the General Welfare Clause, the power to tax, and he said this is not a penalty, this is actually a tax. Now, how did he get to that? Well, first of all, it's very puzzling because the word tax was used in the original draft of the legislation, and then it was changed, actually changed from tax to penalty. And second of all, the word tax is used elsewhere in the legislation, so Congress quite clearly knew how to say tax when it meant tax and how to say penalty when it meant penalty. And the purpose of the tax, of course, is to raise money, whereas the purpose of this penalty was to raise exactly zero. It was supposed to force people to buy insurance. The government wasn't looking to raise money. As a matter of fact, it would be contrary to the purpose of Obamacare. The idea was to get everybody to buy insurance so nobody would pay that money. So it was not a revenue-raising matter, which was what taxes ordinarily do. And if you asked the president, Obama at the time, what this was, he called it a penalty. Why? Because he didn't want to be accused of raising taxes. And if you look at the statute, it cites as its authority the Commerce Clause, not the power to tax. Still, Chief Justice Roberts said, no, we're going to consider this as a tax, and that's justification for the constitutionality of Obamacare. Which brings me to the next case, because the next case is about the Commerce Clause, and that was the justification that the administration actually used. Even though the court decided it was an exercise of vacuum power, the administration had contended Obamacare was justified as a regulation of interstate commerce. So what is the regulation of interstate commerce? Well, this is a case maybe you've all heard of. It's pretty infamous, and that is Booker v. Filburn, a 1942 case. And the question in that case was whether or not Congress's power, acknowledged power to regulate interstate commerce, extended to acts that were not interstate, were not commerce. You know, it sounds like the answer would be self-evident, but it was not self-evident. Mr. Filburn grew wheat on his own farm within a single state. He didn't buy the wheat, he grew it. And he didn't sell the wheat, he ate it, or he gave it to his farm animals to eat. So this was during the Depression, and the Roosevelt administration wanted to bolster the price of agricultural products because they were declining greatly. So, you know, Econ 101, if you want to raise the price, you have to restrict the supply. So Roosevelt, not Roosevelt personally, but in effect, the Roosevelt administration said to Mr. Filburn, you have to stop producing so much. And Filburn said, by what authority? Is the federal government telling me how much wheat I can grow? And Roosevelt said, by the authority that we are regulating interstate commerce. And Filburn quite logically said, well, it's not interstate. It's all on my farm, which is in one state. By the way, there's no commerce involved. I'm not buying and I'm not selling. I'm growing and I'm eating. And the court took a look at it and said, Mr. Filburn, you just don't get it. And if you weren't growing this stuff, you would have had to buy it. And if you weren't eating it all, you would have some left over to sell. So by growing and eating instead of buying and selling, you're obviously having an impact on the amount of goods that are available in the markets to buy and sell. And considering in the aggregate all the other folks that are doing the kinds of things that you're doing, this will have a substantive and a substantial effect on interstate commerce. So that opened up a second set of floodgates for the regulatory state, regulating just about anything and everything under the rubric of the Commerce Clause. And it paved the way for the sort of noxious notion, so the administration claimed, that Congress can even punish the failure to engage in commerce, the failure to purchase a product. In the case of Obamacare, that product was health insurance. You don't buy it, you're going to be punished. And that was unprecedented. As you may know, it's illegal to buy health insurance across state lines. So there's no interstate market there even to be regulated. And further, if Congress can mandate the purchase of health insurance, why could Congress not mandate the purchase of exercise equipment or a new fuel-efficient car? You know, the list goes on and on. So the individual mandate that says you have to buy health insurance, which, as you know, President Trump is now taking care of, it doesn't exist anymore. But that individual mandate would have extended the dominion of the federal government to virtually all manner of human conduct, including non-conduct, the decision not to do so. And that was the legacy of Wicker v. Filburn. So where do we stand with respect to the Commerce Clause after the Obamacare case, which the court finally drew the line and said you can't do that? Well, we started off, it says, the Constitution says, that Congress has the power to regulate activities that are interstate and that are commercial, that is, buying and selling goods. That's what Congress has the power to do. Then came Wicker v. Filburn. And Wicker v. Filburn expanded that enormously. It says it doesn't have to be interstate, and it doesn't even have to be buying and selling. It can be any economic activity which, considered in the aggregate, even if it's all within one state, can have a substantial effect on interstate commerce. And that was the rule under Wicker v. Filburn for a half a century, until a case called U.S. v. Lopez in 1995. U.S. v. Lopez involved a prohibition against having a gun within 100 feet of the school. And Mr. Lopez was indicted under federal law, even though he could have been indicted under virtually every state law, because virtually every state had the same sort of law. But the federal government decided to indict Mr. Lopez, and Lopez says, under what authority? And the federal government said the Commerce Clause. And the court took a look at it and said, wait a minute, we've gone a step too far. We've said after Wickard and Filburn, you can regulate, the federal government can regulate anything that has a substantial effect, any economic act that has a substantial effect on commerce. But this is not an economic act, this is just possession of a gun. Nothing to do with commerce. It's not an economic act. So what do we mean by an economic act? Well, commerce is pretty clear, it's buying and selling, so those are economic acts. But in addition, economic acts would include, for example, mining, manufacturing, distributing, consuming, and buying and selling. Those are all economic acts. But possessing the gun, that's not an economic act. So the court finally drew a line and says the Commerce Clause doesn't go that far. U.S. v. Lopez, the indictment, was not authorized under the Commerce Clause. And that became the new rule. It has to be an economic act. Any economic act that in the aggregate has a substantial effect on commerce, but not a non-economic act. And then came Obamacare. And the Obama administration wanted to expand the definition even further. So it would cover not only economic acts, but non-acts. That is the decision not to engage in an economic act. And finally the court drew another line and said, no, we're not going to allow that. So Obamacare was not authorized under the Commerce Clause because the court said you cannot engage in this bootstrap operation whereby you, the federal government, force people to engage in commerce and then you purport to be able to regulate them because they're engaged in commerce. That's bootstrap, and we're not going to allow it. So the Obamacare decision by the Supreme Court was a disaster because it justified Obamacare based on the exercise of the taxing power when in fact there was no tax involved. It was a penalty, not a tax. But on the other hand, there was a good element to the Obamacare decision, and that was it finally drew another limit around the Commerce Clause and reined in the power of the government to regulate just about anything and everything. Now let me switch gears for just a moment and tell you about another power. You know, these are powers of Congress that have been abused, and they've caused this behemoth government that we now have, this enormous explosion in the power of government. So that the culprits are, so far, the general welfare clause, the power to tax. That's one big culprit. Second, the Commerce Clause, the ability to regulate anything. Here's the third one. This is called the non-delegation principle. So a lot of people, not law students, haven't heard of the non-delegation principle. Article 1, Section 1, the very first provision in the Constitution after the preamble. It says, all legislative powers vested in Congress. Now, why did the framers say that? Because they were smart guys. And they knew that if Congress were vested with lawmaking authority and the people didn't like the laws that were passed, that people had a remedy. They could get rid of the congressman and have a vote in the House every 2 years. Well, here's the problem that's grown up over the years. Suppose the law is murky. Nobody quite knows what it means. Obamacare. Or, even worse, nobody even bothers to read it because it's so huge or because it's incomprehensible. Again, Obamacare. Dodd-Frank. Perfect example. And what happens if the law is murky? And then Congress delegates to one of these 320, roughly, administrative agencies, the alphabet agencies, the FCC, the DC, the CND, the ICC, on and on, the power to regulate. That is the power to flesh in the details of these murky laws and decide how these laws will govern the obligations and benefits, obligations imposed on and benefits dispensed to private parties. Well, then what happens is, of course, you no longer have a remedy if you don't like the idea. You can't vote these guys out of office because these guys are not elected officials. They are unelected bureaucrats who are appointed officials, and the voters, the taxpayers, do not have recourse to force these folks out of office. So if you like this principle of delegation of legislative authority, even though it says in the Constitution that all legislative authority is vested in Congress, if you like the principle, then of course you will have loved the Troubled Asset Relief Program, which we called the bailout back during the big recession, which basically turned over U.S. lawmaking power to the Treasury Department, which is an executive branch agency. First it was Treasury Secretary Henry Paulson, and then became Treasury Secretary Timothy Geithner. So Paulson decides, without any congressional input, in the case of the bailout, Paulson decides that we are going to purchase toxic assets from these banks that are too big to fail. And then along comes Geithner, and he says, no, I think we're not going to do that. What we're going to do is directly inject capital. And we're going to become, government's going to become shareholders in these banks to stop them from failing. We're not going to purchase their assets. We're going to become shareholders. Then he changed his mind after that. He said, what we really need is a public-private partnership. Whenever you hear those terms, just grab hold of your wallet. And what it means is that the public, namely us, taxpayers, are going to incur all the costs, and the private parties, namely the big banks, they are going to reap all the benefits. And that's exactly what happened during the bailout. And of course, along the way, Congress expropriated $180 billion to bail out the insurance giant AIG, and even a few tens of billions of dollars to bail out automobile companies, despite an explicit declaration by Congress that there was to be no automobile bailout. So what did the court say about this? Well, basically, the court said, yes, we understand that the Constitution says that Congress is supposed to not enact legislation and not pass the buck to these administrative agencies, but, governing is a pretty complicated thing, and so we're going to have to make an exception. This delegation of legislative power to the agencies in Washington, D.C. is going to be okay as long as Congress lays down what's called an intelligible principle so that the agencies know how to conform their regulations to the intent of Congress. So ask yourself, what was the intelligible principle in the bailout? It was basically, let's make things better. And that's hardly what you call a coherent principle. There were no guidelines. And the net result of that is that Washington, D.C.'s alphabet agencies are now operating overtime, a little less so under President Trump. We have Health and Human Services that regulates the healthcare industry, the FCC is trying to control the internet, the new Consumer Finance Protection Bureau, making a lot of mischief under Dodd-Frank. So if you want to know whether that's a big problem, I think you have to look to the tabulations of these laws, and you'll find that the regulations now dwarf the statutory law. The regulations imposed by administrative agencies dwarf the laws passed by Congress. The Code of Federal Regulations, which is where all these regulations are compiled, is now more than 200 bound volumes, about 6 times as large as the U.S. Code, which contains all the laws passed by Congress. So this is an enormous problem. Okay, shifting gears once again, this time back to the Bill of Rights, the free speech. And the issue is one that you hear about every time we get close to an election, and even sometimes when we're not close to an election, and that is campaign finance. And the key case here was a case called McConnell versus Federal Election Commission, which was passed back in 2003, litigated back in 2003. And so here was the issue. The campaign finance reformers, folks that don't like money in politics, they had this quixotic idea that money and politics and elections just don't mix. So they passed McCain-Feingold, which I'm sure you've heard about. And they passed that in 2002, and we know how well it worked out because the next major election was 2008. 6 years after the law was enacted, more money was spent in that election than in any election in the history of the universe. And of course now, for another 10 years, we are spending much, much more money than was spent even back in 2008. So McCain-Feingold, by any definition, has been an abject failure. That bill, McCain-Feingold, ultimately was passed as BICRA, PCRA, the Bipartisan Campaign Reform Act, which Congress upheld, which the Supreme Court, I think, inexplicably upheld. It was litigated. In this case, McConnell versus FTC. McConnell, as in Mitch McConnell, the Senate Majority Leader from Kentucky. And the court decided in litigation that this law, BICRA, this law was constitutional, which meant that political speech, which is what this law is all about, was entitled to less First Amendment protection than Klan speech, for example, than pornography, than flag burning. So each of those is, and in my view, ought to be constitutionally protected. But believe it or not, if a corporation, let's take a publishing company like Random House, if a corporation published a book, and somewhere in that 600-page book were 3 words, vote for Trump, or vote against Trump, anywhere in the text, the entire book under McCain-Feingold could have been banned. So we're not supposed to be about banning books in the United States, and that's why the Supreme Court finally agreed to take a follow-up look at this litigation. And the new case, which I'm sure you've heard of, is Citizens United versus FE, Federal Election Commission, FEC. And happily, from my perspective, in January 2010, the court overturned 2 of McCain-Feingold's most onerous provisions for respecting corporate and labor union political expression. The first provision was that no publication can expressly say vote for or vote against an identified candidate. Now, if there was any greater infringement on political speech, I don't know what there could be. And the second is just about as bad. No broadcast ad can even name a candidate. You don't have to say vote for or vote against. You can't even name a candidate within 60 days of a general election and 30 days of the primary. So the case was about, the Citizens United case was about a movie called Hillary, the movie. And she was then a candidate. This was not the first, this was the latest time before that. So it was okay to show the movie in theaters. It was even okay to sell it on DVDs, which didn't have any TV ad, any broadcast ad of any type, saying that the movie was available to be seen or that the DVD was available to be purchased, because of this provision that said you can't use a broadcast ad to name a candidate. So Justice Kennedy, in a 5-4 opinion, realized how ridiculous this was. And he mentioned that, look, corporations and unions don't speak with one voice. Corporations often favor policies that unions will oppose, so we have countervailing power involved. And by the way, even within the corporate community, we have a big company like Walmart. They were very much in favor of Obamacare. We have another big company like Whole Foods. They were very much against Obamacare. So there are even countervailing powers within the corporate community. Now, the issue in this case was not, even though the media has portrayed it this way, it's not whether corporations are persons. Whether corporations are persons is a great body of literature that addresses that issue. A lot of legal scholarship addresses that issue. The issue in this case, however, was whether individuals should be free to associate and pool their resources for purposes of obtaining political messages, to express themselves as they wish, whether they do it individually or they do it through a union or a corporation or a partnership or an LLC or an LLP or a club or Students for Liberty. That was the issue. Not whether corporations are persons, but whether we have the right to associate and pool our resources. And furthermore, you'll see in the press that after Citizens United, we're going to have an avalanche of money pouring into these coffers of the political candidates. Nothing could be further from the truth. It is illegal, post-Citizens United, for a corporation or a labor union to contribute a nickel to a political candidate. What they can do now, that they couldn't do before, is they can pay for an ad. They can independently spend their own money, independently, and advocate for the election or defeat of a candidate. They cannot transfer the money to the candidate himself or even to the political party. So, do we still have a problem with respect to money? Maybe. But the proper answer for large expenditures for political speech is, probably more money, more speech, so that the voters can pick and choose what speech they want to believe and what speech they don't want to believe. And ultimately, if that system doesn't work, and it's possible that it might not, then the answer is a constitutional amendment. We can't treat the Constitution as just as some loophole and we're free to violate it whenever we want. The text of the Constitution makes it quite clear in the First Amendment, the very most fundamental form of speech that's to be protected is political speech. Now, as for money, I think it's just a symptom. The real problem, the underlying problem, is that overweening government has wormed its way, has insinuated its way into just about every aspect of our lives. So, we have this pervasive regulatory state and distributive state, and it creates huge incentives for profiteering. Why should we be surprised that the lobbyists and the corporations and the labor unions are running to Washington, D.C. to grab their share of the benefits? Because Washington, D.C. is where the benefits are doled out. So if we want to stop this process of seeking favors from government, then don't give government the favors to dispense. We limit the powers of government the way the Constitution intended they be limited. So we cut down government to its legitimate size. We will minimize the influence of big government because big government won't have favors that can be dispensed in their favor. All right, next case, another different topic, and that is, again, a case you probably heard of. It involves eminent domain, property rights. This is a case called Kelo versus the City of New London. So Mrs. Kelo, she has a cherished home, and I think I heard you're going to have a screening here at the Little Pink House.
Next semester we're going to have a screening of this case.
Yeah, well, the Little Pink House has showed the movie that I've seen in the Institute for Justice has been instrumental in getting that movie produced, and I'm on the board of the Institute for Justice, so I have some connection with this case. Mrs. Kelo lives in a cherished home. You know, she's lived there for many years. Along comes a private developer who says to the City of New London, listen, if you'll just condemn Mrs. Kelo's home, and her neighbors, by the way, and let me have that property, we're going to do lots of good things for the city. We're going to create a lot of jobs, and of course, we're going to raise the tax base, so you're going to collect a lot more taxes. And Mrs. Kelo wasn't wild about the idea. So she said, look, what about the Fifth Amendment? You know, the Fifth Amendment, the Constitution says that private property can't be seized by anyone except for public use. And what does public use mean? Well, you know, typically it's highways, schools, government office buildings, military bases, etc. What it doesn't mean is to take a home and turn it over to a private developer who says that he's going to be able to work out a deal with Pfizer to put up a pharmaceutical plant, and along with that, there's going to go like a lot of hotels, a lot of office buildings. So we're going to substitute for Mrs. Kelo's home this private development project having nothing to do with public use. And the court had to decide whether or not the public use clause was violated. And Justice Stevens wrote the opinion, and he decided the Constitution says public use, but it doesn't mean public use. What it means is public purpose, public benefit. And, you know, if you look at this, you can see that there's public purpose being served because it's important to have more jobs. And it's important to have a higher tax base. And both of those create, they have a public purpose and they create a public benefit. So they allowed Mrs. Kelo's home to be taken and the homes of her neighbors. And of course, if that's going to be the criteria for seizing your home, then nobody's home is safe from the government doorway. Because it's always possible to take a residence and turn it into something commercial or industrial and generate more jobs and generate a higher tax base. Of course, we would find noxious the notion that everybody's home is at risk. Now, fortunately, there's an epilogue, and that is thanks to the Institute for Justice, which litigated and lost this case in court. They then mounted a media campaign, and there was an outcry after this case, the opinion in this case, an outcry more than any other case, I think, that perhaps, except for Roe v. Wade. And the outcry was, how in the world can we allow private developers to use government in order to confiscate property from other private parties? And so as a result of this media campaign, there was legislation passed. Not in the courts, legislation from the state legislatures in about 45 states now. They have passed legislation to one degree or another has trumped the Kelo decision. Now, of course, state law can't trump federal law. So the federal law still says what the Supreme Court said. But state law can always grant you more rights than the federal law grants you. And there's a lesson there. The lesson is that the federal Constitution sets a floor, not a ceiling. The states can always do better in terms of your rights. And that's what the states have done in 45 states. They've outlawed or made impermissible the use of the eminent domain power for purposes of economic development. So there is that is a lesson that the states can give you more rights. There's another lesson, and that is more than one way to win a case. You can lose in a court and go to the court of public opinion and get some remedy there that you couldn't get from the Supreme Court. There is another interesting fact, and that is that even though Suzette Kilo's home was, and her neighbor's homes were relocated, the Pfizer plant never happened. It was caught with the big recession. Neither did the hotel, neither did the apartment buildings. So if you go driving around New London, Connecticut, what you're going to find is not a Pfizer plant, no hotel, no commercial office, no Mrs. Kilo's home. You will find a lot of vacant lots. That's what you'll find. So much for economic development. All right, let me mention one more case and then see if you folks have questions. And that case is called U.S. v. Caroline Products. And this is about economic liberty. And again, this is something the Institute for Justice is also very much involved in, as is the Cato Institute. Does economic liberty include the right to form your own business without unwarranted government restrictions? And the court decided in this case, the answer to that was no. Economic liberties, such as the right to contract, the right to own property, to use property as you see fit, those economic liberties get less protection than the so-called fundamental liberties. So our rights have been bifurcated in this case called U.S. v. Caroline Products. They've been divided into segments. The court vigorously protects some rights, the so-called fundamental rights, like voting, like the rights that are expressly listed in the Bill of Rights, speech, religion, etc. But the court minimally protects other rights, such as the right to make an honest living or to start your own business without unwarranted restrictions by government. And all this was done in a single footnote. The infamous, if you go to law school, the infamous footnote 4 of U.S. v. Caroline Product. And because of that footnote, the court will only take a close look at, rigorously scrutinize regulations if they infringe on what's called a fundamental right. So what's it mean to be a fundamental right? And I think this is an interesting term. To qualify as a fundamental right, said the Supreme Court, the right has to be, and these are terms of art, quote, implicit in the concept of ordered liberty, or deeply rooted in the nation's histories and traditions. So how you define the right, whether you define it narrowly or you define it broadly, makes all the difference and determines whether the court's going to really take a look at the regulation or simply going to rubber stamp it and say whatever the legislature said is okay with us. And if you want an illustration of how this works out in practice, there are a couple of really interesting cases that I think reveal this bifurcation of rights. The first case, I'm not going to get into this in any depth, but just by way of illustration of this fundamental concept. The first case is Raish v. Gonzalez. And this is about a lady, Mrs. Raish, who wanted to use medical marijuana in California. It was legal in California, even though illegal under federal law. And she had a doctor's order to use it, and she was using it because she was sick, and she thought that it did her some good. And whether it did or not wasn't the issue in the case. She thought it did her some good. She wanted to use medical marijuana. She says, I have a fundamental right to put into my body what I want. I'm assuming the risk. I'm not bringing any harm to anybody other than myself, if even to myself. And so the court had to decide, was that a fundamental right? So one way to look at it as a right is in this very broad context. This is the right to use my body as I see fit. Another way to look at the right is very narrow. This involves the use of marijuana for medical purposes. That's a narrow conception of the right. Well, if you look at it narrowly, the use of marijuana for medical purposes is certainly not implicit in the concept of ordered liberty, nor is it deeply rooted in our nation's traditions and culture. And that's what the court did, looked at it narrowly. So Mrs. Reich loses. It's not a fundamental right, so the court's going to allow the regulation to exist, the federal regulation that says you can't do this. And if you want a contrast, there's a case in Texas called Lawrence v. Texas, involved two gay guys having homosexual relations, and they're prosecuted. And they claim under what authority? And of course, there's an indictment, criminal indictment for sodomy in the state of Texas. And they say, well, you can't do that. This is a fundamental right. And the court had to decide, was this a fundamental right? So you can look at it broadly as a right for two people to get together and do what they want to do and not bring harm on any other people. And so there's no harm other than, if at all, to the two people involved, and there's no force involved. Or you could look at the right very narrowly, this is gay sex. The court looked at it broadly and said, yeah, this is all about the right to engage in voluntary acts without visiting harm on anybody else. And so Mr. Lawrence wins. So how is it that Lawrence wins and Reich loses? Nobody knows the answer to that. And which characterization is correct? They're both correct. Reich is trying to live life with less pain. She's also using medical marijuana. Lawrence is pursuing a personal, private, consensual relationship. He's also engaged in homosexual conduct. So the court can rule how it wants, based on whether it defines the right narrowly or broadly. And that's the foolishness of bifurcating our rights into these fundamental and non-fundamental categories. And our argument at the Cato Institute is that all rights, whether they're enumerated or they're unenumerated, whether they're fundamental or they're not fundamental, all rights have to be rigorously protected by the courts. The courts have to be vigorously engaged in making sure the legislatures comport with the dictates of the Constitution. And that's especially true for these economic liberties where the court has rubber stamped them because they've deemed them not to be fundamental. And what purpose do those economic liberties serve? They protect us against legislation that we have a lot of nowadays, which basically is designed to help politically connected special interests, protect them from competition by upstart companies, and those regulations, sad to say, are rubber stamped by the court. So, to wrap this up, in a free society, we shouldn't have to ask for government participation or government permission to participate in an election. We shouldn't be forced to buy health insurance or bail out automobile companies. And those abuses of government power and others like them, I think, can be minimized only if the court ensures that the legislative and the executive branches are bound by the chains of the Constitution. And regrettably, the Supreme Court has more than occasionally been derelict in fulfilling that constitutional obligation, and I would say it's long past time to restore constitutional government. Okay, that's it. I'll try to answer any questions you have about what I've said or any other subject.
Before we get started with questions, guys, if you could keep it to like 15 seconds or shorter, that way no one monologues. That'll be great. If
We
starts
could
to-
save a little time by dispensing with the answers. Yeah.
John Prisco, representing party of Collier County. First of all, thank you, sir, for your time tonight.
My
Also,
pleasure.
thanks to Students for Liberty for putting this on, our friends at Eagles. As an aside, the 17 amendments you mentioned, I believe one nullified the other, so technically it's 15. My question is, I believe it's called Chevron. In light of the 1910 amendments, which you raised, maybe you could give us a little background on that and where it might stand.
The Chevron case is a case that established that administrative agencies, when they make regulations, are to be given deference by the court. That is, the court is not to rigorously scrutinize these regulations unless there's an express declaration by Congress in the statute that indicates that the administrative agency doesn't have the discretion that it purports to exercise. Or, more likely, the statute is pretty murky about all of this, And the regulation the administrative agency has passed is simply unreasonable. Or to put it in a nutshell, as long as the administrative agency reasonably interprets the statute, it will not be rigorously scrutinized by the court. So that's the Chevron doctrine. It has gone a long way to protect administrative agencies from scrutiny by the courts. It's one of the major culprits that has enabled us to have the administrative state, the regulatory state, the vast expansion of government power that has existed because Congress has allowed the agencies to do a great deal more than they have in fact done. Now, mind you, this is a second order problem. The primary problem is the one I illustrated. Congress should not be delegating to the administrative agencies the power to make laws. Chevron comes in play after that delegation has occurred, and that delegation should have been unconstitutional to begin with. But once the delegation has occurred, then the court has to often face the question, how much deference should we give to these agencies in the way that they've interpreted the law? And Chevron says, as long as they did it reasonably, we're okay. So Chevron basically has taken the power to scrutinize these regulations away from the courts. The courts are very deferential.
Hi, Kendall Coughlin. I'm a recent two-year graduate of FGCU. Thank you for being here. Also, thank you for writing Very Dozen. Dr. Bradley Hobbs gave me that book to write a paper in Moral Foundations of Capitalism. And I got an A+ because you so accurately portrayed everything.
That was my goal in writing the book.
Awesome. So back when the book came out around 10 years ago, you were asked what your outlook was on Supreme Court justices and their decisions going forward, and that was when Obama was taking office. You cited that, well, he might stack the appellate courts, but there's not really a choice for him to make in the recent years of his presidency, and that Justice Ginsburg was written for him. Now, lots has happened with, Scalia and, what happened with Merrick Garland, and also I just saw Ginsburg lifting weights on the Late Show last night, so I don't think she's going anywhere.
She started that on November 9th last year.
Right, and I was just wondering, has your outlook changed, or is it any, the same, or how do you feel about it?
Well, President Obama did not have an opportunity to do much about the balance of the Supreme Court. He was able to appoint justices, but there was just a liberal for a liberal, so you don't have an alteration in the balance of the court when that happens. On the other hand, he did have a great impact on the lower courts, the trial courts and the appellate courts. And so he pushed those courts in a much more liberal direction. You can find that on almost all the appellate courts. The D.C. Circuit, for example, which is the second most important court in the country, moved from a predominantly conservative mix of judges to a predominantly liberal mix of judges. And that's had an enormous impact on a lot of legislation that is brought before the D.C. Circuit. Most of the administrative cases involving these agencies, those regulations have come up to the D.C. Circuit. So there's been a big switch there. Now, the Trump administration has had an opportunity because of Scalia's death, and not to alter the balance, because they ended up with portions for probably in ideological terms, roughly a swap. Whether or not Trump is going to have a further opportunity depends on the health of the liberals on the court. I mean, I don't think the liberals are likely to retire voluntarily during the Trump administration. One could hardly blame them, right? I mean, they want to see their ideology perpetuated. Trump is obviously not going to do that. So they won't retire. But if they have health problems or an accident or who knows what, there could be an opportunity for Trump to, particularly if he gets reelected, there could be an opportunity for Trump to alter the mix of the Supreme Court. But right now the court stays the way it's been for some time. 4 liberals, 4 conservatives. Justice Kennedy, we don't know from time to time how he's going to vote. He tends to vote more conservative, but not always.
Yes. Given the progressive outlook of many judges in the system and their either hostility toward or ignorance of the Lockean notion of negative rights, do you think that a resurgence in Ninth Amendment jurisprudence could possibly pave the way for more activist judges to create more positive rights? Do you think there's that danger there?
Well, sure. I mean, it's not only a potential danger, it's a danger that manifests itself all during the years of the Warren Court. So that's exactly what they did. They created a lot of positive rights. You know, the rights that we now have by statute, not constitutionally, but the courts have not overturned these statutes. The right to welfare, to a minimum wage, to housing, to education, to health care, etc. So these are all positive rights because they impose affirmative obligations on other people, and they have been sustained by a court that has been deferential to the legislature. And those are courts like the Warren Court during its liberal years. Now, there's been some movement back in the other direction when the justices switched from predominantly liberal to, a little bit tilt toward the conservative side. So we've seen some of that reined in. But most of the reining in of these regulations is now being done by executive, unilaterally by President Trump. You can make the case that the executive has no power to do this unilaterally, but of course what he's doing is reversing what Obama did unilaterally during Obama's years. Yes.
There are a number of people who felt that if we could have loser pays for court cases, that especially when it's the government versus an individual, that would improve things. Is there anything in the Constitution that would allow Congress to say that the loser has to pay?
Sure. That wouldn't be good. I think Congress can see that. Congress has, with respect to federal courts, they couldn't affect state law, but Congress could certainly impose a user pays rule on the federal courts consistent with its powers. Now, whether it's a good idea is a separate question. And the argument is that loser pays makes sense because a lot of people find it's prohibitively expensive to litigate and lose. It would be out a heck of a lot of money. The argument on the other side is that when you have alternative means of giving poor people access to the courts, that you should keep loser pays. Because loser pays imposes upon each party the obligation to pick up its own costs. So what are the alternatives? The alternatives are contingency arrangements, so that the loser may not pay anything unless he gets something back. So the lawyer agrees to work on a contingent. And of course the other alternative is class actions. So those are two alternatives to a loser pays environment. But I think it's notable that almost everywhere is loser pays except the United States. The United States the United States has a system where everybody pays their own costs. Other places in the world, for the most part, have a loser pays regimen. So it would be constitutionally permissible for the federal courts to have a loser pays regime dictated by Congress, but it couldn't affect state law. Yes?
At the beginning of your lecture, you mentioned the founding amendments 1 through 10, and you discussed Amendment 9 and 10. And then and before that, you mentioned the other 17 amendments that have been added over the years. I'm curious about the 20th, actually, and what the classical definition of libertarianism says about minority rights.
Well, let me read you the 20th Amendment. The 20th Amendment is fairly long, so I'm only going to tell you its relevant parts. It sets, if this is the one you're talking about,
Yes.
it sets the terms of the president and vice president and specifies that the succession of president and vice president and changes the succession that was in place prior to the 20th Amendment. So if the president's out of office, then the vice president takes over, and the president, the Congress can provide by law for the case of the death of any of the persons whom the House of Representatives may choose as president. So what is a libertarian view on this? I don't know that there is an official libertarian view. You can't say it's unconstitutional because it's in the Constitution. So I think it's perfectly permissible for the voters who have, after all, ratified the 20th Amendment to determine what the method of succession is going to be if a president or any other major official is no longer able to serve. Of course, it's been modified now by I think it's the 25th Amendment, which gives the cabinet the ability to force the president out of office, or at least the ability to start that process. Again, I think a reasonable exercise of the people of the United States voting to amend the Constitution to add both of these to the Constitution.
Recently we heard that President Trump has put these tariffs on China, and we know that this was the result of trade war. We can see now with the Dow closing at minus 700 points as of today. What's your response, and what do you think will happen now if we go into a trade war with China? How will this affect us?
Well, this is a little bit outside my my bailiwick, but you know, folks at the Cato Institute who specialize in these things, we're in favor of free trade. Now, that doesn't mean we're in favor of the theft of intellectual property. It does mean that we're in favor of free trade, and to the extent that some foreign government subsidizes their industries, that's a benefit to us. It means we get cheaper products at the expense of Chinese taxpayers. What could be a better deal than that? So we're certainly in favor of free trade, even if it's unilateral free trade. Bilateral free trade would be the best thing. Unilateral free trade would be better than barriers. But again, that doesn't mean we're in favor of theft. And theft of intellectual property is something that has been occurring and should be punished. And to the extent that the president decides to use trade as a weapon to punish, I think is misplaced. The punishment itself should be there should be punishment, but I think he's chosen the wrong means because these means are going to backfire and harm the U.S. economy just as much as they harm the Chinese economy.
There's a really good book called The Case Against the U.S. Supreme Court by Erwin Chemerinsky. If you've read that book, he cites some of the same cases you do, as well as Plessy Ferguson and Dred Scott and the Kerry Buck case. But he ends his book by saying that actually we need the court. It's a good thing. Based on that, I mean, look at the Constitution. Out of all the different articles, it's the smallest of the Constitution as far as the three judicial branches go. And some people argue that there's not really a co-equal branch of government because it is so small. Do you agree with that, or what would be your view?
Well, let me back up a little bit. We didn't include Dred Scott and Plessy. I mean, I agree they're horrible decisions. We didn't include them because we looked at this from the New Deal on in terms of time frame. So these all preceded the New Deal, and there were lots of other really bad cases back then as well. Now, with respect to the length of the Article 3, which is the judicial branch article of the Constitution, I don't think you can judge the importance of a branch of government by the number of words devoted to it in the Constitution. I think far more important is Marbury versus Madison, where the Supreme Court said that the judicial branch is going to have the power of judicial review, which you won't find literally by text in the Constitution. But the courts interpreted it, the Federalist Papers implied that there would be a judicial review. That's made all the difference in the world, because it means that the Supreme Court is the final authority over the constitutionality of a given law, and that gives the court quite a lot of clout, notwithstanding the fewer number of words devoted to the courts in our.
Well, it's not just a fewer number of words, but I guess it's because it's not really well defined as the legislative branches. I mean, you've outlined all the different elements of that. But the judicial branch, as you indicated, does not have anything regarding judicial review, how many justices can sit on the court because of the court back issue with FDR and so forth. So I'm not just looking at the number of words per se, but I'm just looking at how it's less well defined than the other two branches.
Yeah.
So did they give it the same deference as they did the other two?
Well, of course, less well defined simply means, as in the context of your question, less well defined in the Constitution. It doesn't mean that it can't be defined by statute. So what happens is if there's some murkiness or ambiguity or missing elements in the Constitution, then it's up to the Congress to adopt policies that give us a better idea of what these rules are, such as how many judges have to serve on the Supreme Court, or other. In the case of the court itself, decided there would be judicial review. So the Constitution does leave some gray areas with respect to the judicial branch. But that doesn't mean that they remain gray. It simply means that the process of but making them more explicit is turned over to the legislatures, the U.S. Congress for the most part. That's not a bad thing. It means that people have a much more direct input about some items that might be considered to be procedural. You know, things like how many justices you have to do. Yes.
Oh yes, I'm with Charlotte County COPWATCH, and the reason why I came tonight is like you said, the courts are out of control, government's out of control. There's so many ordinance laws, state statutes, federal statutes. That's literally like one of the things I talk about, on my Facebook, YouTube is everything is illegal and you are not free. So that's one thing that I do with COPWATCH is who's policing the police. At least in Charlotte County, I'm trying to expose how out of control it is. What do you have any other ideas how to stop it, expose it? I mean, in Charlotte County, they're putting people in jail for one joint. You have a bowl, you go to jail. You have a piece of weed in your pocket, you go to jail. It's completely out of control.
Yeah. Well, first, I would not go so far as to say government is out of control. I mean, I think, as you can tell by remarks that I've made, that there's some problems, some big problems. But out of control is a little bit of an exaggeration. We are still, I think, free, relatively free, particularly when you look at some of the other countries around the world. So for that, we can be thankful. Now, that said, you're absolutely right. The abuses of police power. Cato has, and I encourage you to look at our website, a criminal justice project, reform project, and we are in favor of legalizing drugs, for one thing, if you want to reduce crime overnight by a huge percentage. That would be one way to do it. And by the way, that way would also have an enormous impact on gun violence. We worry about 17 people being killed in Parkland. We should be worried about it. It's a horrific thing. There's 17 people killed in downtown Chicago every 2 weeks. So if you want to get rid of some of the gun violence, just legalize drugs, because the drugs are what's being used. You can't settle disputes by going to court and have your contract enforced, so you settle in the streets with guns. So that would be one thing, one element of criminal justice reform. And another is a vigorous application of the Fourth Amendment, the privilege of being secure against unreasonable searches and seizures.
Mm-hmm.
So we do have a criminal justice reform project that is very vigorous in pursuing these sorts of things. And I encourage you to look at the Cato website to see what the activities are. It's headed by a very fine attorney, Clark Neely, who used to be with the Institute of Justice and is now with the Cato Institute. Yes.
So there's a movement growing on, I would say more on the conservative side, but it's convention of states. Do you believe that this is needed, or do you believe that it's kind of overblown?
Well, the way in which the Constitution has been amended every time is by the process that I mentioned earlier. 2/3 of the states both houses have to propose amendments, and then they're ratified by 3/4 of states. An alternative is to have a convention of the states, and that convention would propose the amendments, and then they would be ratified. So people have suggested, some people have suggested that's a good idea because we've found that the process requiring Congress to propose these amendments is a non-starter, both because of the deep divisions within Congress and the difficulty of getting, even if there weren't deep divisions, 2/3 voting, pretty big hurdle in both houses of Congress. Personally, I have had mixed views about the convention process. The reason for not having it is because people are worried about a runaway convention. That is a convention that exceeds its powers and begins to consider amendments that it was not originally called to consider. And if you think, well, that's ridiculous, they can never do that, bear in mind that that's exactly what happened when the Constitution was adopted. Because they came to the Constitutional Convention to modify the Articles of Confederation. And what did they end up doing? They threw the whole thing out and completely rewrote the Constitution. So it can happen, and that's a concern. However, I've come to feel that that's not that big a concern, because after all, you still have the requirement that the amendments that have been proposed have to be ratified by 3/4 of the states. So that, again, is another final hurdle. So on balance, I think I'm in favor of a convention of the states. I hope that they will ask me to dictate what amendments are going to be considered. There are a lot of them that would be very harmful.
Has the Russian investigation intensifies and closes in on President Trump. If he fires Special Counsel Mueller, is that an impeachable offense?
Yeah, I think so. You know, there's different views of that. It's a very close call. The court's never considered anything like this, so we don't really know the answer. One view that Dershowitz has been prominent in espousing is you can't fire a guy for doing what he's authorized to do. He certainly is authorized to fire either directly or in this case it would have to be indirect. He'd have to get Rod Rosenstein to do it, who's the acting Attorney General, giving Sessions recusal. So the president does control the executive branch. Mueller's an employee of the executive branch, so he can be fired. The contrary view is that one has to look at the motive. And if the motive is a corrupt motive, that is an intent to obstruct justice, then notwithstanding that he has the power to do so, he does not have the power to do so for a corrupt purpose, and therefore it would be an impeachable offense. So I'm inclined toward that latter view, but I do think that it's very difficult to determine what the motive is. You'd have to find a smoking gun, and of course that's what Mueller's looking for. A smoking gun with respect to firing Comey, or with respect to negotiating with the Russians about impeding our election process. They're looking for a smoking gun. In the same sense, you'd have to have a smoking gun to suggest that that Trump's motive, if he fires Mueller, is the corrupt one of obstructing justice.
Do you have any suggestions on how to properly exercise our right to redress of grievance? From what I've seen, it doesn't really even exist anymore without hiring a lawyer. Is there any way to do that without hiring a lawyer or without having maybe ACLU help you out or something like that?
Well, I guess it depends on what grievance you're trying to redress. You know, the ACLU will help you out with some grievances. The Institute for Justice is sort of the ACLU of the libertarian movement, and they will help you out with lots of other different grievances. Occasionally, the ACLU and the libertarian movement, I'm a financial supporter of the ACLU, so I believe in the ACLU with respect to certain.
Is there any government agencies that you know of that actually, I mean,
You
you're
know,
right to redress
there's
a
a public
grievance against
defender,
the government?
legal aid. There are ways of people who can't afford a lawyer to get a lawyer. Public defender, legal aid, contingency arrangements, class action arrangements. So there are means of access to the courts. But I mean, I think you're right that redress of grievances is a difficult thing. It certainly favors the rich. There's no question about that. But look, the rich are favored in just about everything. They're favored in the purchase of
Favors
cars.
the government too.
Just to push back a little bit on what you said earlier, there's a group of us here who are heavily involved in various civil rights issues in Section 1983, 14th, Fifth Amendment rights violations for people. You'd indicated that, you know, you think that basically we're free. And I think it's a relative term depending on who you're talking to.
Mm-hmm.
We have 5% of the world's population and 25% of the world's incarcerated individuals.
Amen.
Many of them are minority and minority people and socioeconomic limited people. And my concern is that their freedoms, once you have a felony conviction, your freedoms are very curtailed. Where you live, what you can own, where you can go, and so forth. So I think when you say we're free, it all depends on whether or not you've been one of those people caught in the system that's now, and there's another book too about how science has done a great job in convicting innocent people and sending them off to prison, then exonerated later by other scientific evidence. There's so much going on in the system, so I guess my concern is that I think it depends on who you're talking to unless you're the one who's caught up in the system.
Well, look, it's a perfectly valid point. I agree with you 100%. There are lots of folks who are in jail who probably shouldn't be in jail. There are lots of crimes that have been statutorily declared to be crimes that shouldn't be crimes. After all, the prison population would be reduced by a very meaningful percentage if you simply eliminate drug-related infractions. About 50% of the federal prison population is drug-related stuff. Not to mention the billions of dollars being garnered by the drug gangs and the terrorists because of the illegal trade in narcotics, all of which would be eliminated if we legalized drugs. And I'm additionally in favor of lots of other criminal justice reforms for the very reason that you accurately stated.
I have a question. You mentioned Kilo versus the City of New London, and in that case, I think you would agree that in court of public opinion and the level of public outrage that occurred because of that case resulted in such as with the Home Building and Loan Association versus Blaisdell, where the contracts clause came into play? Do you think that it could backfire in issues like that? Because you mentioned in your book that you kind of paint the corporation in that situation as the victim, and in today's society, it's very hard to see a person using their home as not the victim.
Yeah. Well, look, the question is not so much whether you feel sorry for the person losing their home. I think we all would feel sorry for a person who loses their home. The question is, what's the remedy if a person borrows $100,000 to pay a home and then tells the lender, goodbye, I'm not paying it back. And what the court did in the Blaisdell case was simply say that we're going to force these financial institutions to continue to provide financing even though they're not being paid back. So it abrogated private contracts. That's what was objectionable about it. Even though, yes, one feels sorry for the folks that lose their home. And by the way, the contracts clause, which has been moribund ever since that case, Blaisdell case, is now going to be revisited. And there's a case coming up this term in the Supreme Court about the very same issue. Can a state abrogate the terms of a private contract? It's going to be very interesting. It's the first time the contracts clause has been revisited in over 80 years. And by the way, what do you do when you want to redress your grievances? So there are a number of things you can do. And so let me mention 4 of them. The first that comes to mind is vote. And, you know, that's pretty obvious. I'm not a big proponent of voting. I haven't voted for ages. Just because of the, you know, there's a theory in public choice economics called rational ignorance. Basically, I'm oversimplifying now, but it says that the probability of your vote being decisive is roughly 0, particularly in the presidential election. Everybody else thinks it's high, and that ain't going to happen. And whereas, so on the benefit side, the benefit that your vote is going to generate is probably 0 because your vote's not going to matter. It'd be one vote one way or the other. On the cost side, there's a considerable cost of voting. You have to take off work, go to the polls, digest the information, etc. So on a pure cost-benefit utilitarian calculus, it probably doesn't make sense to vote. Now, I'm not suggesting that you don't go vote. Some people consider it a civic responsibility. I don't dismiss that sentiment. I don't feel it's my civic responsibility because I exercise my civic responsibility in a lot of ways that I think are a lot more important than voting. So what else can you do? You can write up, and you can write op-eds, you can write letters, letters to the editor, articles in your local papers, your neighborhood papers. There are all kinds of ways. The third thing you can do is debate. I don't mean formal debates when you get up here and stand behind the podium. I mean debates in your neighborhood with your friends. You talk about these issues, become well educated. The last thing you can do, a little bit self-serving here, you can donate to the Cato Institute or any other institute. I hope that if you consider the ideological motivations that you'll think that Cato serves your best interest. But if you don't, I'm sure you have whatever institute promotes the sentiments that you believe in. And that's a way of doing it without becoming an expert yourself. Because that's what we have as experts. That's what we're in business for. We're a think tank. We develop intellectual ammunition that influences the process of public policy. So we do that. And so on the libertarian side, it's Cato. On the liberal side, it's the Brookings Institution. On the conservative side, it's the Heritage Foundation. On the very liberal side, it's the Center for American Progress. And there are lots of these think tanks and all kinds of other local organizations that do this sort of thing. So, how do you donate? Well, that brings me to the last thing you can do is that get yourself rich. That's what you want to do. Get out and make yourself a lot of money. Providing you're doing something you like. My son's doing immigration law because he went and he was going to get rich working for a big law firm. He hated it. So he switched. He's doing pro bono work, 75% pay cut. So yeah, the first criteria, you got to like your work. But beyond that, I think getting rich is a heck of a good idea. And it does enable you to vote with your money. And that's a very effective way of voting, is to make sure that your sentiments are broadcast. You can do that if you can afford to do that. Other questions? Okay, thank you all very much.
Man, fail. County. This is Charlotte County COPWATCH, and I wanted to explain what fair use is. You can use pieces of news articles if you're doing it for news reporting, you have commentary, and you're doing it for education purposes. So that's what fair use is, as you can see right here. Another reason why I wanted to make this video is to let you know I have just joined with Patreon. A nice thing with Patreon, I make no money on YouTube. They took the money away years ago, and so this is another way to give, and it's a nice thing too because you can give monthly. You can give $1, $5, $10, whatever. I do 4 to 5 hours a day on trying to wake the sheeple up on how corrupt it is and different ways that you can fight the corruption. So Patreon is a way that you can do it, and then of course the old way is still there. Donate to Sheriff County COPWATCH with PayPal or credit card. So keep that in mind. 4 to 5 hours a day. I make no money, but the corruption happened to me, and I'm sick of it. So I'm trying to wake people up. But my wife would love it if if we could get some help out there. There's 47,000 subscribers. Just think if each one of you subscribers just gave let's say actually yes, $1 a month. 47,000 subscribers gave $1 a month. That would be awesome. That's not going to happen. But anyways, that would be great if it did happen. But do the math in your head. Just think about it. Like I said, 4 to 5 hours a day. I get no money from YouTube. YouTube has gone nuts. You can't do anything anymore. They're taking the money away everywhere. So these are a couple different ways that you can still help out with all this time that I put in. And as you know, I'm in a special situation where at least I can do it. 4 to 5 hours a day. We have a cleaning company during the day. That's what allows me to do this, and we're debt free. So this is my hobby. I don't go fishing and all that other crap. I try to save the world. So help me out to make the wife happy, man. In fact, if you guys did give $1 a day, and there was 47,000 of you, and you did it, and each of you gave $1, and that was every month, oh my God, yes, I could quit. I could start suing them. Another idea too that we have is if I got some funds, we could actually contact everyone that has been ticketed and or arrested and put in jail and start sending them postcards to let them know we're here, and to see if everything went all right, and if it didn't, find out their story. So we could even do more investigations and more lawsuits. Lawsuits take money. So just think about that. 47,000 of you so far right now. $1 a day. $1 a month on Patreon, or $5 a month Patreon, 10, 20, whatever. Just do the math in your head, help out. This is a lot of work every single day. Thanks.